Before we get started, we would like to remind everyone that the information and the opinions expressed by the speakers today are their own and do not necessarily represent the views of their employer.
Good morning, good afternoon, and good evening, everyone. My name is Brett Tishler, partner at White & Williams in Philadelphia, and I'm here with Big Mike, the Lunchbox Associate Mike Abed, and we're here to talk to you about Workers' Compensation Subrogation Tales by the Water Cooler. Part 1, How to Handle a Case, aka What Are We Getting Ourselves Into? Good morning, Mike. It is morning right now still. How you doing?
I wish I were more awake, my man.
Well, there's coffee for that. I got news for you right before we start. I'm having a bathroom remodeled right now, and all I can think about is every time these guys are picking up heavy things and doing electrical things, that I don't want them getting hurt on my premises because I don't want to deal with my own loss.
Poor Mrs. Tishler. Is this really what you're like at home?
Unfortunately, it is, Mike. Okay, so if you listened to our 3-part podcast series before, Help Me Help You, how working with claimants counsel can maximize your lien recovery, we know there are many different moving parts in workers' compensation subrogation. We know there's the injured worker, the plaintiff's workers' comp counsel, the defendant's workers' comp counsel, the employer, the insured, the employer is the insured, third-party plaintiff's counsel, there's witnesses, there's experts, there's so much to keep track of. It's hard.
It really is. And today we're hoping to be able to discuss how these various things interplay with each other and how they handle or how they affect potential recovery.
Absolutely. So I think what we should be talking about first is, what happens when we get a new case? Oh my God.
Did you really leave your ringer on?
I left my ringer on, but it is Rob Caplan. So let's see what he has to say. Hello.
What are you doing? Where are you?
I'm doing a podcast with Mike. I told you I was doing this. What's up?
We have a brand new loss that just came in and it could be big. We need to discuss it ASAP.
Well, can it wait until the podcast is over? I mean, we have like 11 people that need to hear what I have to say. Maybe they want to hear what Mike has to say.
No, they don't.
11 people? Seriously?
All right, listen. Why don't you just come in here and we'll discuss it, okay?
Fine. I'll be there in a minute.
Well, geez, if that wasn't pre-planned. Sorry, folks, but this is how it happens on a day-to-day basis. Rob will call me up in the middle of whatever it is I'm doing to tell me about the new loss we just got. So, Mr. Rob Caplan, so nice of you to join us.
Well, it's nice that both of you are actually working. That's a rare occurrence.
I wouldn't go so far as to say working, but we hear you.
Well, Rob, now that you're here, why don't you explain to our listeners about the program, the Workers' Comp Subrogation Program, and how it came to be and what it is you do?
Well, other than watching over you two and several other people, well, thanks. I'm Rob Caplan, and I head up the Work Comp Subrogation Department here at White & Williams. And, I didn't always do this for a living. In fact, back in the dark ages in 1988, I started as a defense lawyer. And I did. Yeah, well,
I was a defense lawyer, too, at one point, Mike.
Well, I represented, for 10 years, I represented major product manufacturers. And
I represented morons who didn't know how to drive, but that was another story.
Well, representing major product manufacturers like chainsaw manufacturers and nail gun manufacturers and just all different kinds of products in horrible work-related accidents. I saw really the dark side of dangerous products and how they were designed and manufactured. And after 10 years, I had enough of that, and I decided to switch sides. And I decided I would go really to the other side and help workers' comp insurance carriers and injured workers recover their liens and damages instead of defending the manufacturers, who I found had often knew of the dangers of their products in their design and in their manufacture.
Absolutely excellent. And now we do just workers' comp subrogation. Let's talk about that. Workers' comp and workers' comp subro are two sides of the same coin, right? Workers' comp is just an injured worker getting their medical bills and indemnity payments made, their wage loss. But then there's the subrogation side, and that's what we concentrate on. So can you tell us the difference between workers' comp defense counsel and subrogation counsel?
Well, I'll do that. But really, before we get into that, I mean, when I started this practice way back when, back in 1998, really 2008, I realized how incredibly complex it was.
Do you know I realized what college I wanted to go to in 1998?
Well, picking on old people is not a really good look for me. That being said, I'm still much better looking and much more active than you. So there you go.
That's not what my mom tells me. She says
Okay.
I'm the handsomest.
There you go. But no, seriously though, it is an incredibly complex practice that not everyone can do, even though a lot of people try to do it as what we call a one-off. And you asked about work comp defense counsel. A lot of people who do what is primarily workers' comp, and we hear it every day, guys, right? We hear, it's almost a misnomer, workers' comp subrogation. Do you guys do workers' comp? We do not do workers' compensation. We do workers' compensation subrogation. So we're not workers' compensation lawyers. We are third-party lawyers looking for why an accident happened and who caused it.
I always tell people that I know enough comp to get in trouble, but not enough to practice it.
Right. And the interesting part about that is workers' comp itself, the notion of workers' comp is very specific. Okay. And you're looking for compensability. And really that's it, did an accident happen on the job and will someone be compensated for it? What we do is a 50 state envelope of every workers' comp statute. And we deal with workers' comp counsel. We deal with workers' comp defense counsel in that separate litigation. We don't do that, but we have to be aware of it. And then we deal with everything else, which is called the third party case. And that's really what you asked about. We're getting the liens back pursuant to those 50 different state statutes and all the case law that's been born out of all of those statutes. And we have to know everything about it. That's why it's not a one-off. That's why it's what we call a niche practice, meaning we do it every day. The 7 lawyers in this department do it 100% of the time, every day in all 50 states.
Well, why don't you explain to the listeners, why can't a workers' comp defense counsel, let's say who practices in state X, whatever state they're in, why can't that workers' comp counsel also do workers' comp subro?
Well, it's a conflict. It's a direct conflict. If they're actually trying to determine whether a loss is compensable, they can't also try and find out who the third party is who's responsible, because they may be implicating their own insured and potentially taking away rights of the injured worker. And that is a potential conflict. So we don't have that same barrier. We have to, as I said, we have to know about the workers' comp enough to be dangerous, but we're not determining compensability. We take it that next step to find out who the third parties are and then determine whether or not we can collect on the lien.
Now, obviously, this is an incredibly complex practice. As Brett mentioned, we have 7 people in our group. Rob, I'm new to workers' comp subrogation. How would you say our group measures up to the other practice groups in the country that do this?
There's no one that measures up. And the reason is there's 1 or 2 people in every, I'd say, subrogation department across the country that do workers' comp subrogation. And it's because it's so complex and it's costly and it's time consuming. Oh, and we're not always getting a huge fee out of it, but that's what we do for our clients. We're taking the difficult cases. We're taking the difficult jurisdictions. And we could talk about this for hours. We don't have hours today, but we could talk about it for hours. There are a lot of states that you can't even get a lien recovery. They're called the made whole states. And, I'm sure that you guys will probably do another podcast on made whole stuff. But
foreshadowing much?
Yeah.
PTSD much?
Yeah, but there we go. I mean, the answer is we know the ins and outs because we do this in all jurisdictions every single day.
Now, I will say it's been my experience, and first of all, Mike, you're not new to workers' comp subro. You've been doing it, 2 years?
I've been doing it for 4 years, but I will say this is the first and only job I haven't made complete mastery of in 6 months.
Let me jump on that real quick, Mike. You said you're new to this, and you asked why we do it better than anybody else. I've been practicing law now for close to 34 years. I've been doing this for 24 years, and I learn something new every day. And if you're trying to do this as a one-off, it's just not going to work. It's dangerous. There's potential for screwing up. That's why we do what we do. I mean, there are so many issues. We talked about complexity. You asked about work comp defense counsel. You got to deal with work comp defense counsel. You got to deal with work comp counsel. You got to deal with third party counsel.
That's what we were talking about before you came in, all the different parts.
You got to deal with the employers. You got to deal with what's called, the insured's lawyers. There's so many lawyers that you need to deal with. I know you were dealing with the insured's lawyers in difficult jurisdictions like Georgia because of the made whole states, and all of these different. You got to deal with OSHA.
And I would say, listeners, if for more on all those parties that Rob was talking about, listen to our first 3-part series that Mike and I did. I don't even remember what it was called because it was a really long title, but it was our first 3-part series that we did earlier this year. And I think that was really well received by the 9 listeners and Mike's mom. But going back to the defense counsel, workers' comp defense counsel, it's my experience, Rob, that typically the only consideration on the workers' comp claim or the workers' comp defense counsel is of most prime importance is just to close that workers' comp claim. It's not really so much getting money back on the lien. Is that your experience as well?
Absolutely. They want to close the case. That's what we hear from work comp defense counsel and workers' comp departments in general. And sometimes that's a good thing. If there's a huge future exposure, they want to close the claim down. It's an administrative expense to keep a claim open. But that's not what's always best. In fact, that's not what's best for workers' comp subrogation, because our job is to recover a lien. And the two often conflict. And what we found is what we look for is what's best for the insurance carrier as a whole. And, there's a mantra that you hear from the work comp defense side all the time when there's a lien out there, and that's waive the lien. Waive the lien, waive the lien, waive the lien. And we always get worried about that because waiving the lien means no subro recovery. And if you just waive the lien without looking at other considerations, like what's the future credit? Is there a big liability recovery? What's going to be best for the carrier? You may be missing something. You may be leaving money on the table.
Now, as a guy who definitely enjoys his cake, Rob, I've heard you say to me before, you can have your cake and eat it too sometimes.
That's true.
Do you want to elaborate?
Sure. In a third-party case, let's say where you got a lien of $500,000 and and Brett's had this situation dozens of times, and you got a liability case where there's going to be a $3 million recovery, you can have your cake and eat it too, because in a situation like that, and there's a potential lien exposure or a future exposure of, let's say, $1 million, a $3 million third-party recovery is going to pay your lien back of $500,000 100%. So you're going to be able to recover that and also get a future credit that's going to wipe out that $1 million exposure. That's just the facts of the matter. But invariably, work comp defense counsel will try and use that $500,000 lien as a chip in their pocket and say, let's waive the lien. Why should we have that lien if we can just waive it? That's ridiculous. You can get it.
We'll waive it to close the claim.
To close the claim.
The claim.
But you can close the claim anyway, because when you have a future credit that will essentially close the claim, that's just as important. That's just as important because that can always be leveraged to close the claim anyway.
So the bottom line, listeners, is we need to, in any workers' comp subrogation loss, when you have a third-party case, you have to analyze what is this going to settle for potentially? What is this worth? What is the lien repayment worth? And how do the future credits come into play? Are there future credits? Every state's different. So the analysis has to be different. But a blanket waive the lien to settle the claim isn't always the best answer. Now, anyway, Rob, because we're running short of time here, thank you for hijacking the podcast and explaining your life story. Now, you did come in here with a case you wanted to talk about?
Well, my life story is very interesting. We can keep talking about that. But you know what? Let's start talking about the case. And how about we let the listeners in on the conversation? It could be interesting.
Well, I mean, it kind of deals with the topics we had in mind for the podcast, so long as we talk about the actual case.
I think me being here, just about double the listenership.
What are you talking about? We have 11 listeners at least. And our podcast series, our last one, which you can find on the WW website, was a masterpiece series. I mean, geez. Listen, Rob.
Well, I'm sure we can all listen to Rob and Brett argue like the odd couple all day. That's all the time we have today. I think the takeaway here is that workers' compensation subrogation is its own beast.
Last time.
With workers' compensation plaintiffs' counsel, workers' compensation defense counsel, the workers' compensation adjuster, workers' compensation subrogation adjuster, the injured worker, the third-party claim, the employer, and so much more. There are a lot of moving parts and interests that you have to balance and consider in order to obtain any recovery. This is why workers' compensation subrogation is such a niche practice. Simply sending a lien letter or a notice letter and then waiting for third-party counsel to get involved is not going to be enough in the majority of cases. Tune in next time on December 19th, 2023 for Workers' Compensation Subrogation Tales by the Water Cooler, Part 2. We got a new claim? Now what?
This podcast should not be construed as legal advice or to give a legal opinion on any specific facts or circumstances. Prior results do not guarantee a similar outcome. The contents of this podcast are intended for general informational purposes only, and you are urged to consult a lawyer concerning your own situation with any specific legal question you may have.